Was it your understanding that the Attorney General was taking a position in that case that facts related to a prosecutor by an expert were protected by work product and therefore not subject to the statutory requirement that those discussions be memorialized?
No, sir. That if I gave that impression, I gave the wrong impression. It was my impression that discussions of work product were not something that I needed to provide. I mean, that was something. But it was also my impression from talking with the Attorney General, well, not the Attorney General directly, but with Mr. Hart from the Attorney General's office, that they were taking the position and arguing to the court that a district attorney or assistant district attorney who interviewed a witness prior to trial did not have to memorialize and provide a written copy of that statement. I was still responsible, obviously, for giving information that was information that was given to me somehow. And I've said all along, I'm not suggesting that the information on the DNA was not information I shouldn't have given. I should have given that. I'm just saying that because I was not taking notes and because I didn't make a point of writing it down, I didn't have it in a position where I could find it later and say, oh my goodness, I didn't give this.
So the requirement to take, your understanding was that what was at issue was the requirement to take notes with any witness that you might be talking to, whether that entailed matters that might be otherwise subject to work product protection, or whether or not it included any discussion of facts that might be exculpatory in nature for which you would have an independent duty to disclose.
I'm not sure that I understood your question. I certainly agree that we had an independent duty to disclose anything exculpatory in nature regardless of how it's discovered.
Right, so you're not relying upon that position of the Attorney General to excuse any failure to disclose facts that were exculpatory in nature that were conveyed to you by Dr. Meehan? Absolutely not.
And whether or not they were exculpatory in nature, if they were facts related to his investigation, I believe that I was supposed to relay those. Whether you look at them as exculpatory or non-exculpatory.
That's my next question. Whether they're exculpatory or not, what in your discussion with an expert, even a testimonial expert, relating to his findings would you consider to be subject to work product protection in any of it?
When a district attorney specifies in a statement exactly what he went over with a witness and what subject matter was covered with respect to, in this case, an expert witness, then giving a statement with respect to exactly what was discussed would indicate the manner in which the state intended to present that witness at trial. In other words, when I talk to a witness, I'm probably not going to go over every single thing in a witness's statement that was ever said, because I'm not going to be interested in everything that was said. I'm going to be concentrating on individual parts of that statement that I think I either need to explain or deal with. And so if I only ask about certain things, then a report of that conversation, of the statement that was made in reference to that, would indicate what I was concerned about or what I intended to use out of that statement at trial.
Let me ask you this. Do you consider any of the discussions that you had with Dr. Meehan, whether it's 2 or 3 at that time, were they covered in whole or in part by the work product doctrine?
I consider some of the discussions to be, yes, sir.
Now, at that time, now, none of that involved, did it, any preparation for his trial testimony, because indeed, no trial had even been scheduled.
That's certainly true. But any time that I talk with an expert witness, it will be with an eye toward how I'm going to use him at trial. But I don't want to I mean, obviously, I'll be glad to answer any of the court's questions with respect to this, but I'm not suggesting that I did not have an obligation to turn over that material. I'm not trying to say that this is an exception that would excuse me from that. That is not my point at all. If anything, it just has to do with the reason that I don't take notes in these situations.
Okay. Were you specifically aware at that time of the statute that on its face requires you to take such notes?
You're talking about 15A-903?
Yes, sir.
Yes, sir, and that again that's where my understanding of the Attorney General's position, State versus Shannon, was that the prosecutor did not have the responsibility to take those notes. I understand that is now the minority opinion from the Court of Appeals. But it is...
Well, if it's the minority opinion from the Court of Appeals, it's not the law.
No, sir. As a matter of fact, it's not the law, but the statute specifically said that it would not define the terms, but it would allow court decisions to do so. And no court decision had existed at the time that I made this decision. I'm not suggesting that, I mean, clearly in hindsight, it wasn't the correct decision.
Did you specifically, was it your practice at the time specifically not to take notes in order for it not to be discoverable?
No, sir.
Why didn't you take notes?
I generally didn't take notes because, well, and I did turn over to the disciplinary hearing committee, or the grievance committee, I guess, a very few notes that I took in this case, because they were about, and they have some of these notes. I rarely took notes because usually I only took notes if there was something that I needed to remind myself of or to remember. And most of the time, I mean, there are very few notes, for instance, with my contact with the SBI. And a lot of what they entail is the YSTR testing labs that might do some testing and some telephone numbers, because I would need that to contact them. But I didn't take extensive notes about the actual content of the conversation because I assumed that that would be in the reports that were presented when I talked to expert witnesses.